Hi, everyone. Welcome to another episode of Legals. And so today we have something really, really interesting for you. I am Jamila Little. Today I have with me attorney Tanya O'Connor. Hey, Tanya. I have Alana Greenway,
Hello.
Luby Myrtle, Lisa Knox, and we have a special guest today, Attorney David Haas. We are going to be talking about the verdict and findings of fact regarding the aggravated sentencing factors in the Derek Chauvin case. So as you guys know, sentencing is coming up in a couple of weeks. And so there were some interesting factors that came up recently, and we're going to be talking with David Haas. Lisa, can you introduce Attorney Haas for us?
I will. So it is my pleasure to introduce Attorney David Haas. He is a federal and state defense attorney. Prior to becoming a federal and state defense attorney, he was a former state and federal prosecutor. So he knows both ends or both sides of the courtroom. To be very clear, he handles felony, misdemeanor cases, federal felony cases, of course, white collar matters, tax fraud. He actually has been handling a lot of like rappers and a lot of celebrities that are out in the social world right now. Cryptocurrency cases, like he's done it all. I think his, although he has such an illustrious title, I think that his biggest accomplishment is probably being husband and dad. But for me, his biggest accomplishment for me personally is that he is by far one of my most favorite professors. And so it's an honor to have Attorney David Haas here. He's going to give us his opinion on things because, as you know, we don't specialize in criminals, but Attorney Haas, you have it.
Welcome. Well, it's so nice to be with you guys. I'm adopted legal, I guess, right?
Yes, you're legal.
Yes, you're legal.
Well, thank you all for having me. And this will be fun.
Thank you.
Thank you for joining us.
So now, bringing along the subject, we were talking a couple of weeks ago about the David Chauvin case and how, the sentencing guidelines, since they found him guilty on all three charges, how the sentencing guidelines, we were opining on how that could possibly, play out. Some of us were really happy about the guilty verdict and so forth and had faith in the charging. And then some of us, me, I was concerned because I thought, maybe they're going to be quiet with the sentencing, and that would be where, we would lose justice. So this, I want to say, was it this week that it came out? That Monday, that the judge who we know, the court can do things sua sponte. It looks like, meaning on its own for anyone who's not practicing law. Whenever they say sua sponte, it just means the court decided up on its own to go ahead and do this without anyone asking, has decided that there's aggravating factors that can be used to increase the sentencing for Chauvin. And that is interesting to us.
Yeah, I think it might have been a motion actually filed.
Excuse me?
Yeah, I think the order was on a motion.
Was it on a motion?
Yeah, I think so. The state requested.
I think the judge has to find, in order to get whatever sentencing zone there is in that particular jurisdiction. I think the state asked for 6 aggravating factors, and the court found 5 of the 6.
Okay,
so what does that mean exactly? What does that mean to find aggravating factors, and how does that affect the actual sentence that comes down eventually?
It's a perfect question. So a couple things are sort of going to come into play. And if you remember, before the trial even started, I think the defense appealed because they had charged him, I think, with second, third, and a manslaughter or something like that. And there was a question whether they could charge all of them and they could go to the jury. He's been convicted of all three of those, but my understanding, and it happens even in Florida, is that there's certain offenses that will count as double jeopardy, meaning you can't be convicted of both. So what will probably happen is the state will dismiss 2 out of the 3 convictions and sentence him on the highest one. And that's because jeopardy attaches, and so you can't be convicted of effectively multiple things. And so then the next phase will be the sentencing phase, and the state, with how that particular, again, that state's sentencing works, is that there's aggravating factors that are found. Even though in Florida there's aggravating factors or capital cases, if somebody's going to be put to death, you have to have aggravators. But for up there, if there's certain aggravating factors, it tells you how much time somebody's looking at. And so with Chauvin, the judge found 5 of 6. The only one he didn't find was that it was a vulnerable victim because Mr. Floyd was in handcuffs, and found the others, which were, I think, position of trust and in front of children because there were children watching. And we can go through them all. But the way I think now it works with those 5 aggravating factors there, I think he's looking at a sentence of maybe over 15 years based upon what the judge found. So I don't expect my student to be disappointed come sentencing when he gets, I think, what will be a fairly substantial prison sentence.
Attorney Hayes, one is very interesting because we're attorneys. Right. And everybody always expects you to know everything. So whenever there's an issue, there's like, oh yeah, I know an attorney, they call you. So this is really good for people to see that even the attorneys are looking for experts to explain what the heck is going on, right? And even as you're speaking, so my background, I did very little criminal work and I did not enjoy it at all. So everything you're saying makes sense. I understand the words as they are put together, but I cannot comprehend what you're saying. Okay. So,
I don't blame you.
So just like break it down for me, what does this mean for sentencing? What does that mean, for the appeal? I know that the appeal happened before the trial. Okay, so at some point, an opinion is going to come down, a ruling is going to come, which is going to cause the state to make some sort of decision. How does that affect the sentencing? How do they choose which case that they're going to dismiss? And these aggravated factors, what does it mean for the state attorney? And what does that mean for us who are looking, what should we expect?
That's like
I'm sorry. I'm just like,
okay. Let's try to do one question. Okay. How about, first.
I'll break it down. I think I got it.
Okay, you'll break it down. Okay.
All right. So he's been convicted of three counts. Okay. Mm-hmm. I like how Luby's frozen on my screen. She's like this.
Come back, Luby.
Yelling at me, and I'm not even there. So convicted of 3 counts. I would expect that the state is going to just get rid of 2. It's not going to mean anything for his sentence. Then what happens, because he's convicted of second-degree murder, the judge basically looks at a bunch of things and says, by statute, there's a number of factors here that make particular crimes worse or better than others. So this one is basically deemed worse because of 5 big reasons. And then those factors will carry certain enhancements in how a case gets scored. And so he'll end up scoring, whatever, 15, 17 years, something in there is my guess. So
maybe that's where we should explain further, because many people don't know that there are actually sentencing guidelines. So let's start maybe with explaining the guidelines and how these aggravated factors perhaps provide the court with some discretion to depart from the guidelines and actually impose a greater sentence than is provided by the guidelines.
Sure. And forgive me, because I don't know Minnesota law that well. But
from a federal basis, if you need to.
I know it's from a simple state federal. The reason sentencing factors are put into place, and there's lots of debate about whether they're good or bad, is so that if somebody's convicted of a drug case in Philadelphia, that they are treated similarly as somebody's treated in Miami. And so the sentencing factors and the sentencing guidelines try to seek a uniformity so that sentencings in one part of a state or one part of a country don't differ substantially. And so it's a starting point, at least in the federal system, for judges to start where they're going to calculate somebody's scores. In Florida, for example, the sentencing guidelines, which is a different set of rules than any other state, obviously, they're actually considered mandatory. So if I've got a client that's convicted of sexual assault, there is a level that gets spit out. There's a little formula that comes into play, and then that person gets that amount of time unless there's some plea agreement or some reason to give otherwise. So again, that increases in theory the uniformity. Everybody knows on this call, no two cases are the same. Right. So again, there's all kinds of ways that they could get uneven as well. But for the most part, you're looking at trying to get things even across the state. This one, there's not a lot of murders that are similar to what Mr. Chauvin did. Right. So those are some of the factors, at least aggravators, that the judge will rely upon in how much weight he gives any one of those or the collective of those, I guess, will be seen. But
so what I'm understanding, I guess, let me try to put it in layman's terms, is that for certain crimes, there are guidelines as far as what sentencing should look like. Mm-hmm. Right? Yep. My understanding is that the jury is not going to decide on any of the sentencing, and this is all going to be for the judge. Now, the judge has taken a look at aggravating factors, which could affect the amount of time the sentencing, and it either increase it depending on, I guess, what he looks at and his findings, increase it from the actual sentencing guidelines, right?
Correct.
Gotcha.
You did it much better than I did.
No, I just want to make sure I get it, because I know there's some people out there, and we've all expressed that this could be somewhat confusing. So I think
I have a question. Oh, go ahead, Lisa. Go ahead.
Here's my question, because I want to get to the meat, the rooter, and the tutor of this. Okay. Rooter number one. Okay. There's always this thought that whatever you're sentenced to, you're going to end up having to do maybe half. Like he might have to only do half. Root number one. And then do you want to answer number one and then I go to number two, or do you want me just to throw it out there?
I'll stop there. So okay. For example, in the federal system, a lot of people think that you get 10 years, or even in the state of Florida, you get 10 years. In the federal system, you do 85%, at least 85%. Okay. So a 10-year sentence is 8.5. Okay. In Florida, if you get a mandatory minimum sentence, so let's say there's a gun crime, you get a 10-20 life, you get 20, you're going to do 20 day for day. Oh. If there's a mandatory minimum. If it's not a mandatory minimum, you can get credit, and you get, I think it's about 4 or 5 days for every month or whatever. But they do give you some credit depending on what the underlying charge is and whether it's a day for day or not. But even the federal system, I think California's is pretty liberal in the sense that you do like 3 out of something, but it's not unusual for sentences to go down. The thing that I always tell clients about that is the judge knows how much time you're actually going to do as well. They can factor that into their sentence just as much as we can.
Oh, okay. So even if Derek ends up getting good time because he's on the side of the road doing work release, he may very well still end up doing, 85 to 90% of his time.
I don't know what they do up there, but my guess is he's not going to be on the side of the road.
Okay, well, there's that. All right. There's
unless somebody drags him there.
Right.
There we go. You led right into question number 2. Do you think he's going to be in solitary or protective custody the whole time?
I am sure he will be in protective custody.
The entire time?
For 2 reasons.
Okay.
number one is he's a former law enforcement officer. So even former, just that tag alone is the Bureau of Prisons or state custody anywhere, they really do have an obligation to keep every inmate safe and well.
Right.
It doesn't seem like that when you're in jail, but they've got a very, very big obligation. And so I would suspect that his time will be much more difficult, assuming he's in some sort of solitary or protective custody, because he won't be, I'm sure, in general pop. And again, some of that's going to depend on how he's treated. They may view him and go, well, you did the crime, you're going to do the time just like everybody else. I just have a feeling that would go poorly, and whoever's in charge of that system would have very difficult questions to answer, because again, it's not an eye for an eye injustice as much as some people may want to. And I understand that, especially in this, but they got to try to keep the man safe.
So then can I have a 2B, and then I promise I'll leave you alone. Just let me give you
You have to leave me alone.
So here's the 2B then, because all of this, you made a great point. He is a former officer now. So, bless you, Tanya.
Bless you.
Thank you.
That was not, for our listening viewers, that was not a COVID sneeze. She's good. Okay.
Vaccinated.
So he's a former officer. So here's the question: because of his actions and because they were so egregious, so horrible, set the world on fire, do you think that's going to cause them to go back to his previous arrests, maybe convictions that led to evidence that he found, actions that he took? Do you think that questions his?
I am sure that there will be some sort of, in any one of these cases, and it's not just the George Floyd case, but when you see any sort of incident, there's always some sort of an autopsy within a department, if the department's doing their job worth a damn. They need to, they have to, and they'll go back and sort of analyze things with a different lens. Whether or not they do that or not, I don't know. And again, just because they do that doesn't mean it changes the outcome of a case. He may have been an incidental witness, like all of you know, or he could have been a key witness.
Right.
So, those are all things that I'm sure lawyers in that jurisdiction are looking at, just to sort of see how that comes together.
Okay.
I had a question. So to go back to sentencing and what the judge considers, I had a question. Besides those aggravating factors, what other things does the judge consider in handing down, a sentence, essentially? Because of course I've heard of victim statements and things of that nature. Is that something else that the judge considers?
I am sure that members of the Floyd family, the people who watched it, who were really, I think, some of the most compelling testimony, the young people that recorded it, who herself changed the world, right? I would think direct family victims, Floyd family, will get the first opportunity. They can do that by letter, they can do that by a verbal statement, and that will go for Mr. Chauvin's family and friends as well.
Okay.
Whenever somebody gets sentenced, there's sort of two buckets you put it in. You put it in that the crime that they are convicted of as one bucket, and then you put the person in the other one, and there's mitigating and aggravating factors in both of those buckets. So, how the judge, does that and puts it together, that's how it works.
So does the judge have to consider both those aggravating and mitigating factors?
Yeah, I mean, I'm sure that, the family of Mr. Chauvin will put on, mitigation as much as they can. How much is sort of, relevant and if the sentence based upon the aggravating factors that have been found, if he's ineligible for probation, right? The defense can't get up there and ask for probation.
Right.
So at some point you reach that, it becomes a bit of a dog and pony show and theater in and of itself, because some of this may not impact the sentence if, he's going to get 15 to 17 and the guidelines are mandatory there. Sometimes that depends. He didn't have a plea agreement. Maybe the judge can go higher and the defense is worried about him getting 40 years. All those things can come together in how a judge will look at sentencing. It's a very difficult thing. I mean, I've talked to a lot of judges, and I'm sure you guys have too, but in criminal court especially, I think one of the toughest things any judge has to do is lay down a sentence on somebody, because how long is long enough and how long is too long?
Right.
And that's a very difficult thing to determine for anybody, no matter how heinous the offense. Sometimes those mandatory life sentences make it easier, but it's those ones where you really, how much is too much punishment? And I don't know if I'm not saying that's in play here or not, but that's always a very tough thing for a judge to look at.
Yeah, I can only imagine having to make that decision.
That's got to be hard. And it's also got to be hard to, as for that judge to not go too far to where it can easily be over the limits and so forth, I guess, too. That would be a struggle any judge would have.
Yeah.
Mm-hmm. Yeah, absolutely. So then I have just one last question.
You said that twice now.
I know, but just one last question for this minute. That was the other few minutes. So, but here's the last question of the day. And that is, as a defense attorney, you've been in his defense attorney's shoes. What's the next move? What's the next play?
Look, the next thing is going to be obviously mitigating the sentence and getting it as low as you can after a conviction. And then the appeal will be next. Whether this lawyer stays on and handles the appeal or not, I got the impression, at least, that it was a fairly clean trial. I don't think anything about Maxine Waters is going to impact, any reversal from any sort of solid legal theory that I can think of.
I mean, you say that again, though.
Yeah. I mean,
no.
One thing I will say, and I think this is we can slip too far, is that even as much as we may want President Biden to step in and say, we hope that the jury does the right thing, I think we go too far when politicians enter into, criminal cases or even civil cases. I think they need to stay out of that. And you don't want that pressure on a judge or anything else. And I think that to a fault in any case. Chauvin's been convicted of a horrible thing, especially for somebody doing that. But at the same time, he shouldn't be punished even more because of how bad everybody else thinks he is, especially people in power. So that's my 2 cents and my only soapbox there. But
that's why we got separation of powers, right?
It should be. I mean, it shouldn't weigh in at all. And that was, again, not going to be anything for an appeal, but you still don't like to see people do it.
Right. So with that being said, because we know that in the life of a busy defense attorney such as yourself, you're out here, you're making things happen and playing detective and investigator and all these other things too. So we're not going to keep you long, but we do want to thank you for gracing our stage today.
Don't you ever think that I won't come back. I'll come back as often as you have me.
And we will have you back again for sure. So thank you once again. Legals, you know what? I love the fact that we can have these great conversations about serious society topics. And I enjoyed this conversation. And thank you again, Attorney Haas. I do look forward to seeing you all in the next couple of weeks. So then we can talk about our favorite TV shows too. We got to have balance. We got to have serious and light. We got to have it all.
Yes, ma'am.
Everybody, we thank you for coming and joining us with the Legals of Tampa Bay. Shoot us messages if you have any questions, any concerns, any topic ideas that you want to hear us talk about. Let us know. But in the meantime, it's been a pleasure. Take care. We'll see you next week from your Legals and Attorney David Haas, the only Legai, the official.
Bye.
Thank you all.